ഞാൻ പറഞ്ഞ
Safik sir, good afternoon. Can you able to hear me, sir?
Good afternoon, sir.
Can you able to hear me, sir?
Yes, sir.
Yes, sir. Yes, sir.
Safik sir, can you able to hear me?
Yes, sir.
Okay,
Am I
sir.
audible?
The session will start. Yes, sir, you are audible. The session will
Okay.
start within a minute, sir. Let me ask my vice principal. Akash, can you able to hear me? Akash, sir?
Yes, sir. Yes, sir. One more minute.
Shall we start the session? Anjana, shall we start? Akash, sir,
Yes, sir. We can start, sir.
yeah. We ask Anjana to start. Shall I start? Hello? Am I audible?
Good afternoon to all. I would like to welcome you all to the second session of Impact Lecture sponsored by MOE's Innovation Cell, AICTE, New Delhi. I would like to invite Dr. S. Kadirve, IIC President, National College of Pharmacy, for the introductory speech.
Good afternoon. Meetings to all of you. Am I audible?
Yes.
Okay, sir. So on behalf of National College of Pharmacy, I, Dr. Kadirvel, IAC President, welcome you all to this Impact Lecture Series sponsored by MOU Innovation Cell, AICT New Delhi. The Impact Lecture Series is structured to and it's designed to teach students and to provide information about innovation, entrepreneurship, and concept related to IPR, that is intellectual property right. So now we have a second session. Morning session was given by Jyoti Madam. Now we have the second speaker, Mr. Shrinikla Officer from of Technology, Trivandrum, Kerala. So coming to IAC, and I'd like to tell, IAC was started in our college in August 2021, and within 10 months, we got one rating released by IAC rating, and then we got a sponsorship. And then next month, we are going for awareness program. It will be again sponsored by MIC, Innovation Council for the Resource Person, National Pharmacy Center for conducting this IPR program. So we are proud, and I like to thank my principal, Sujit Verma sir, and vice principal Akash, and all my team members for this IAC event. And not last but not the least, I would like to acknowledge our chief guest today, Mr. Shafiq sir. Mr. Shafiq sir was first choice while we are conducting IAC quarter 3 program. Since sir was busy, he couldn't come to deliver speech on IPR. So this time, sir has come to deliver a speech on intellectual property rights and IP management for startup. So we are fortunate enough to have you as one of our speakers, sir. So I'd like to also acknowledge AICT, MOU Ministry of Education Innovation Council for sponsoring us to conduct the event. I thank each and everyone, and I wish all the participants a very pleasant, fruitful, brainstorming experience in this event of learning. Thank you.
Thank you, sir. Now I would like to welcome Dr. Sujit Verma, Principal, National College of Pharmacy, to deliver the presidential address.
A warm good afternoon to all. Respected dignitary, today's resource person, Mr. Shafiq, my colleagues, and my dear students. Indeed, it is very good news to see that the IIC is functioning in a good manner. In a short 1 year period, we have received very good support from the Government of India for conducting various activities, and whatever activities we have conducted, the government has given the recognition, and these all IIC activities is not only for the college, it is mainly targeting to the students. So unless otherwise the students are more active in delivering or active in this particular program, it can be taken to the next level where the government can give more fundings and support to the students to build their career in future. And today's topic, it is intellectual property right. Actually, everything it is related. Ideas, developing a prototype, commercializing, and registering or receiving a patent. This all, it's all related activities in entrepreneurship development cell. So you actively participate, interact with the resource person, because he's he's a technical officer from the Kerala State Science Technology Entrepreneur Development Cell. So he will be having more knowledge. So rather than just listening to him, try to interact with him and make a future career in this particular field. And I thank the IIC members for inviting me to deliver the presidential address. Thank you. I wish all the success for this particular lecture series. Thank you.
Thank you, sir. Now we have the biographical sketch of our chief guest by Ms. Serena, Assistant Professor, Department of Pharmacy Practice, National College of Pharmacy.
A warm good morning to all. Today we have Mr. Shafiq State Council for Pharmaceutical Science, Technology and Environment, KCST. He has been coordinating many activities of Patent Information Center, Kerala of KCST since 2007. He has completed his BTech from University of Kerala, PG Diploma in Intellectual Property Rights from Indira Gandhi National Open University, and General Course on Intellectual Property conducted by World Intellectual Property Organization, Geneva. He is around 15 years of experience in the field of IPR and IP management. He has rich experience in conducting IPR awareness programs and patent databases. He has facilitated filing of many patents, trademarks, industrial design and copyright. Now, he is faculty of IPR program of Kerala Startup Mission, MSME Development Institute, and many other various institutions. We are honored to have you with us today, sir. Welcome, sir.
Thank you, ma'am. Now I invite our chief guest, Mr. Shafiq S., Technical Officer, Kerala State Council for Science, Technology and Environment, Trivandrum, for the session of Impact Lecture. Welcome, sir.
Thank you, madam, for the nice introduction. Am I audible?
Yes, sir.
Okay. So first of all, let me congratulate the National College of Pharmacy, especially the principal and Katrivel sir, for organizing a webinar on the topic intellectual property rights, and also for inviting me to this session, because intellectual property rights, as you may be aware of, intellectual property rights is a very important topic of the present time. If we know that we are all living in the era of knowledge, we are living in the knowledge era where knowledge is power. And the role of intellectual property rights in the technological as well as the economic progress of every country depends upon the high IPR regime. So it is very important that we all should be aware of the significance of intellectual property rights. So in this context, let me once again congratulate the organizers for conducting a webinar on this topic. Last time I was invited for a lecture, but due to some official commitments, I could not attend, but I am happy that I could be a part of this session. So I will directly go to my presentation. I will share my presentation. Is the slide visible?
Yes, sir. Slide is visible.
Yes.
Okay. So the topic which we are going to discuss today is intellectual property rights and the IP management for startups. So before starting the session, I do hope that most of the participants of this program might not be that much aware of the topic intellectual property rights. You may have heard of something about intellectual property rights, but you may not have much deeper awareness on the significance of intellectual property rights. So I have made my presentation on a basic level so that anybody, any person who is novice to this field can understand about this topic. But I'm sure that we are all aware of the term property, right? The property, the tangible property or the physical property which we own. So we know how to legally protect such properties also. If you have a house, we know how to legally claim that the house belongs to me. Similarly, if we have a 5 cents of land, we know how to claim that that property belongs to you. So we are well aware of how to protect our tangible property, or rather the physical properties. There is another kind of property which is intangible in nature. So such properties are called as intellectual property. Intellectual property is nothing but the property created by the human intellect. Any intellectual activity which comes out from the human brain is known as an intellectual property. It can be an invention, it can be a creative works, it can be a design, logos, whatever may be. So any intellectual activity, any intellectual product which comes out from the human brain is known as an intellectual property. So if I have an intellectual property, I should have some legal rights to protect my intellectual property. For that, we have got intellectual property rights, IPR. So what IPR will give us? IPR will give an exclusive right to the owner of the intellectual property for commercially exploiting his intellectual property for a certain period of time. Suppose I have an invention, and if I have got an IPR for that invention, I have the exclusive right over my invention. That is the right which I am getting through this intellectual property rights. So we have got 7 forms of intellectual property rights. Many of these terms might be aware of you. We have got patents, then copyrights and related rights, trademarks or service marks, industrial designs, geographical indications, layout design of integrated circuits, and trade secrets. So we have got 7 forms of intellectual property rights. Depending upon the type of the property which comes out from the human brain, we have got 7 forms of intellectual property rights. And in this session, we will just see about all these 7 forms of intellectual property rights. First one is patents. So patent, the term might be very familiar to all of you. Patent. You might have heard of patents and all. We are always referring IPR as patents itself. It's not like that. Patent is just a form of intellectual property rights. So what patent protects? Patent protects inventions, new inventions. New inventions can be protected by patents. So invention means it can either be a new product or a new process. It can either be a new product or a process. So new inventions are protected under patents. If you have a new invention, you can apply for a patent protection, and patent will give you an exclusive right over your invention for a limited period of time. That means you have the exclusive right to make that product, to sell that product, to use that product, and without your permission, nobody else can even use your nobody else can copy your invention, nobody else can use your invention. So you have the exclusive right over your invention for a limited period of time if you have got a patent for that. So it is an exclusive right. It is a monopoly right also for a limited period of time. So what you have to do to get a patent, that is very important. If you have an invention and you want to get a patent for that invention, first thing you have to do is you have to disclose your invention to the government. You have to completely disclose your invention to the government, and in exchange of that, government will issue the patent certificate. Okay. So if you are not willing to disclose your invention, you will not get a patent. So the primary condition to get a patent is you have to completely disclose your invention. That is the primary requirement for getting a patent protection. Then disclosure is mandatory. Then another important point is that patents are territorial in nature. That means an Indian patent, a patent which is issued by the Indian Patent Office, will be valid only within India. So if you have an invention and if you have got an Indian patent for that invention, that patent will be valid within India only, so that you can prevent any person who is copying your invention in India. But if somebody else in America or Europe or in any other country, if he copied your invention, you cannot prevent them because you have got patent in India only. So that is basically the patent rights are territorial in nature, and the protection will be limited for a period of 20 years. You can enjoy the protection of patents for 20 years, and what happens after 20 years? It will become a public property, so that anybody can make it, anybody can use it, anybody can make modifications out of that. So you have the exclusive right over your invention for a period of 20 years. At the expiry of the patents, the property, that invention becomes a public property. And in India, the patenting system is governed by the Patent Act, Indian Patent Act 1970. Another important thing is that discoveries are not patentable. So you know the difference between an invention and a discovery. Only inventions can be protected by patents. Discoveries cannot be protected by patents. That is very important. Then, for getting a patent protection, we should satisfy 3 conditions. If you have an invention and you want to get a patent for that invention, your invention should satisfy 3 conditions. Which are they? One is novelty. Then we have inventive step, and third condition is industrial application. So 3 conditions are to be satisfied for getting the patent protection. Then first one is novelty. What is novelty? Novelty is nothing but newness. The invention should be new. If you have an invention, that invention should be new. Then only you will get a patent. New means not published anywhere, not used anywhere, not in prior use before, not claimed in any of the patents, not been patented before, not in prior public knowledge also. That means till the filing of patent, only you should be able to know the details of your invention. It should not be published anywhere. It should not be used anywhere. It should not be disclosed anywhere. It should not be patented anywhere. So the invention should be secret only. Only you should be able to know about the details of your invention. Only at the time of filing of application, only a third person came to know about that. That is what novelty means. Then we have got the condition of inventive step. Inventive step means there should be some technical advancement in your invention as compared to the existing inventions. There should be some advancement in your invention, or there should be some economic significance, which makes the invention not obvious to a person skilled in the art, which means there should be some technical advancement in your invention, which should not be clear to a person who is having an average knowledge in that field. a person who is having an average knowledge in that field, he should not be able to identify what inventiveness you have made in your invention. So that is what inventive step means. Technical advancement, or should we have economic significance. That is the second condition. And the final condition is industrial application. That means the invention should be capable of being made or used in the industry. It should be a useful invention. It can be used in the industry. It can be reproduced any number like that. It should be capable of being made or used in the industry. So these are the three conditions to be satisfied for getting the patent protection. Invention must be new. It must have an inventive step, and it must be a useful one. Then only you will get a patent for that invention. Then, as I said, patent protects inventions, but all the inventions are not being patented. As per the Section 3 of Indian Patent Act, there are certain inventions which cannot be patented, even if it satisfies the patentability criteria of novelty, inventive step, and industrial application. These are some of the non-patentable inventions as per the Section 3 of Indian Patent Act. First one is frivolous invention, that is silly inventions, crazy inventions, which does not have any use. Such inventions are not patented. Or the inventions which are contrary to the well-established natural laws, well-established scientific principles, scientific theories. Anything which claims contrary to the established scientific principles and theories are not patented in India. Okay. And another one is the inventions which are contrary to the public order or morality. For example, if I am inventing a device for committing theft easily, through that device, using that device, we can commit the theft easily. Even if it satisfies all the patentability criteria, you will not get a patent for that because it is against the public morality. Or any inventions which are contrary to the, or which causes damages to the health of human beings, plants, or animals are also not patentable. For example, adulteration of food. Such things are not patentable in India. Then mere discovery of a scientific principle, abstract theory, or a discovery of a living thing or a non-living substance. As I said earlier, discoveries are not patentable. So discovery of, if somebody invented or discovered a new principle or a new theory, he will not get a patent for that because that is a mere discovery only. Then mere discovery of new form of a non-substance. We have a substance already. I am just discovering the new form of that substance or the new property of that substance. That is mere discovery only. That is not patentable. And a substance which is obtained by mere admixturing. If we have a compound A and compound B, I am combining both A and B and comes up with a compound C, which has got the same property as that of A and B, then that is not an invention. That is mere admixturing only. Such things are not patentable. Then mere arrangement or rearrangement of duplication of known devices. For example, an umbrella fitted with a torch or a fan. Umbrella fitted with a fan. Umbrella is already known, fan is already known. I just combine both umbrella and fan into a single product. And if it works independently, then there is no invention. It is a mere arrangement only. Such things are not patentable. Then agricultural methods or horticultural methods are not patentable in India. Then method of treatment, surgical methods, diagnostic method, such things are not patentable because, for example, if a doctor invents a new method of treating cancer, new method of performing a operation, he will not get a patent for that. What happens if a patent is granted to that process? Only that doctor can use that process. Others can use only after getting the permission from that doctor. So method of treatment or method of diagnostic is not patentable. Whereas if a doctor invents a surgical device, that can be patented. Methods are not patentable. Then plants and animals involved or any part other than the microorganisms, they are not patentable. Mathematical methods, business methods, computer programs, algorithms, they are all not patentable. Literary work, dramatic work, musical work, artistic work, such things are not patentable. That can be protected by another form of intellectual property rights. Then method of playing a game, method of performing a mental act, they are also accepted from patent filing. Presentation of information. My presentation, this presentation, that cannot be patented because it is a mere presentation of information. topography of integrated circuits, they are also not patentable. And the invention which is related to traditional knowledge, you know about the traditional knowledge, the knowledge which is owned by a traditional community. So that cannot be taken patent. So these are the inventions which cannot be patented in India, even if it satisfies the patentability criteria. And there is one more section, that is section 4, which says that any invention which is related to the atomic energy related inventions are not patentable. Similarly, defense related, any invention which relates to the defense of the nation is not patentable in India. So such inventions are not patentable in India. Okay, these are the inventions which are not patentable in India. Any other invention which satisfies the patentability criteria can get a patent for that. Then there is a big myth that only breakthrough inventions are patentable, only complex inventions, only satellites or rockets, something like that only can be patented. It's not like that. As far as patenting is concerned, simplicity is no bar for getting a patent. You know, basically invention means solutions to the problems. So if you are solving a small problem, it will be a small invention, or if you are solving a big problem, it will be a breakthrough invention. So no matter whether it is a small invention or a big invention, any invention can get a patent if it satisfies the patentability criteria. The best known example is the patent for the safety pin. I don't know how many of you are aware that the safety pin was a patented invention. The patent for safety pin was granted in 1849 to a ordinary inventor in America. The US Patent Office only issued the patent certificate for that safety pin. So if safety pin can be patented, you can imagine about the other inventions also. So simplicity is no bar for getting a patent protection. That is a big myth. Suppose you have an invention, maybe a small invention or a big invention. You have got two options. You can either publish it. You can publish it in the journal, magazine, publish it in the media, wherever you want, you can publish it. And the other option is you can patent it. So what about the disadvantage of the first case, that is publishing? Suppose you have an invention and you have published your invention in a journal, and later somebody else advised you to take a patent for that invention. It is patentable, like that he said. When you approach the patent office will say that that cannot be patented because sorry, you have already published your invention in a journal. Once the invention is published, you will not get a patent for that. Okay. On the other hand, if you file a patent first, if you file a patent today, you will get an application number. Next day, you can, no issue. You will get a patent as well as you will get the recognition out of that application. So we always advise you to first file the patent and then go for publication, because once the invention gets published, the novelty, the first part, novelty, the first condition I said, should not be published anywhere. Even if you are publishing yourself, that will destroy the novelty of your invention. You will not get a patent for that. So if you have any innovative idea, if you feel that your invention is worth filing a patent, then first go for patenting, then go for publication. And if you are opting for filing a patent, what you have to do is you have to check one thing, whether your invention belongs to the prior art. Prior art means nothing but any information which is available in the public domain is known as a prior art. Any information which is available in the journals, magazines, websites, any books, any journal, any documents, any information which is available in the public domain is known as a prior art. And your invention should not be Am I audible?
Yes, sir.
Is my screen visible?
Sir, you are audible, sir, but the slide just went off. Screen, the presentation views. Yes, come.
Yes, it's okay.
Yes, sir, it's okay. It's okay. Sir.
Okay. So any information which is available in the public domain is known as a prior art, and your invention should not be a part of this prior art because the invention should be new. Then only you will get a patent. That is what you have to check. So there is a process called the patent search. We have to check whether the invention is patentable. That process is known as patent search, similar to the literature survey or literature search we are doing when you are doing the research. So similar to that, in the case of a patent, if you are applying for a patent, if you would like to file a patent, before filing the patent application, you do a process known as patent search, because it's very important, because you have an idea, you are working on that idea and coming up with an invention. You cannot be aware whether somebody else has already done, somebody else in any other part of the world, because that novelty means it should be new, globally new. That invention should be new globally. So
I request all other participants to mute their microphones.
am I audible?
Yes, sir.
Yes, sir. Screen is also visible?
Yes, sir. It is seen.
Okay. So we have to check whether the invention is new and patentable. For that, we have to do the patent search. And for filing the patent application, you have to make some expenses. You have to make some fees with regard to the filing of the patent application. So before making such expenses, you should make sure that the invention is worth getting a patent. So for that, you have to do the patent search. And based on the patent search only, you have to take the decision whether the patent should be filed or not. So a lot of reasons for which we have to do the patent search. So these are some of the freely available patent databases in which we can do the patent search. These are the websites of the various patent offices. So if you have an innovative idea, you can search, you can do the patent search on your own through these patent databases. The first one is the website of the Indian Patent Office, that is ipindia.nic.in. That is the website of Indian Patent Office, where you will get the details of Indian patents. Second one is the website of US Patent Office, then website of European Patent Office and all. And we can even do the patent search in Google. Just like we are doing the web search, we can do the patent search in Google also. That is google.com/patents. You can just visit the website. You can type the keywords related to your invention and you can do the patent search. This is the website of the Indian Patent Office. There you can see a menu, patents. You can just click on that. This is the search window. You can just type the keywords related to your invention and the documents, available documents will be cited here. This is the Google patents, in which you can just do a search as we do always. Just type it as a sentence, then you can make the Google search, and after that only the patent documents related to that invention will be cited. No other documents will come. Only patent documents will come. And these are all the patent documents. You can click on this link, it will go to that particular invention. And you have to read that invention. And you have to make sure that your invention is different from that existing invention. Because if your invention is different from the existing invention, then only you can get a patent for that. Then only your invention is new. So for that process, we have to do the patent search. Suppose you have done the patent search and you feel that your invention is worth filing a patent. Then in India, we have got 4 patent offices with the head office at Kolkata and having branches at Delhi, Mumbai, and Chennai. So where we have to file the patent applications from Kerala has to be filed at Chennai Patent Office. And who can apply for a patent? As far as patent is concerned, there is no age limit, there is no qualification requirement, nothing like that. Any person who has invented, who has made an invention, can apply for a patent. Any person who is the true and first inventor or his assignee. I can assign somebody else to file patent on my behalf, or in the case of a deceased inventor, the legal representatives can also apply for a patent. And there are a lot of forms to be submitted while filing the patent application, and some fees are also there. And this is very important. There is something called a provisional specification. This is very important because, as I said earlier, you might have an idea, you may be working out on that idea, but your invention might not have completed. But you fear that somebody else might copy your invention and file a patent, or might publish your invention. Then you can apply for a provisional specification. The invention need not be completed. Just you have to give a brief description of your invention. What is your idea? What you are going to do in a prescribed application form, and submit it at the patent office. You will get a patent an application number. You will get an application number. The advantage is that after that, nobody else can copy your invention. That is the advantage of filing a provisional specification. Just to give a brief description of your invention, and the condition is that you will get 12 months, that is 1 year time, to complete your invention and file the complete specification. Okay, so that 1 year period you will get it. Within that period, you can complete your invention and file the complete specification. So that is the way in which you have to do. You have an idea, you are working out on that. First, you file a provisional, then you can publish it in the journal. No issue. But before publishing, you should file a patent. That is the condition. Just next. Sorry. So that is the advantage of filing a provisional specification. Advantage of filing a provisional specification, you will get priority for 1 year time. You will get priority. That is the advantage of provisional specification. So this is the patent filing procedure in a nutshell. First step is the filing of patent. I am not going to the details because of the time constraints. I am just rushing over this. So first step is the filing of patent application. Then it will be published after 18 months. Then there will be an examination on your invention and on your application. After that, the patent will either be granted or refused. So that is the procedure. It may take even 3 to 4 years time to complete the entire process of patent filing. So this is the patent certificate. This is the proof that you have got a patent. This certificate will be valid for 20 years, and you will get a patent number, application number, date of filing, and the name of the patentee. So that is the proof that you are the owner of an invention. This is the fee structure for filing the patent application. For filing, fee is 1,750. Then early publication fee is there, examination fee is there, expedient examination fee is also there, and renewal fee, because patents are valid for 20 years. But for renewing the application every year for the patent, every year you have to pay the renewal fee. From the 3rd year onwards up to the 20th year, you have to pay the renewal fee to keep the patent in force. So regarding the term of patent, the term of patent is 20 years. As I said, 20 years is the term of patent from the date of filing of application. From the date of filing of application, not from the date of grant of patent, because you may get the patent granted after 3 or 4 years time, but the term of patent will start from the date of filing of the patent application. And as far as patent is concerned, there is a big myth called, there is something called a world patent or an international patent. It's not like that. As I said earlier, patents rights are territorial in nature. Indian patent will be valid only in India. If you want to enjoy the protection, patent protection in USA, you have to go to USA and file the patent application in US patent office. Then only you can get the patent protection in that country. So all the patent rights are territorial in nature only. But there is a shortcut to file an international patent application in which a single application can be filed in the form of a PCT application. Advantage is that once you file a PCT application in the Chennai office itself, you will get a priority for your invention in all the 150 countries. That is the only advantage. You will get a priority for 31 months time. Within that time, you have to complete your invention. You have to file the patent in whichever country you want separately. So that period you will get it as a priority date. Only that is the method available. And other myths like only complex inventions, as I said, safety pin was patented, then publication is more important. It's not like that. Once published, the novelty is lost. Then another myth is like that one can get a patent for an idea. Many inventors are approaching us and they're requesting like, I have a brilliant idea. I want to get a patent for that. Idea cannot be patented. Please note that. If you have an idea, you want to get a patent for that idea, please convert your idea to a product or a process. Then only you will get a patent. Idea as such cannot be patented. That is a myth. And age a bar to get a patent, it's not like that. Anybody can get a patent for that. These are some of the myths related to patents. And as far as patent is concerned, don't lose the chance of getting a patent by publishing it and by using it in the public. Don't publish it anywhere. Don't use it in the public also. And don't wait for the full development. As I said, we have got the provisional specification. Just file a provisional specification first, then you can publish it wherever you want. You will get 1 year time, complete your invention, file the complete specification, and proceed further. So don't wait for the full development, don't publish it and don't use it. That's all about patents. So that is one form of intellectual property rights. Then we have another intellectual property right, that is copyright. So that this term is also more familiar to all of you. Copyright. Is the copyright, is it the right to copy or right not to copy? Copyright. Any answer? No answer? Copyright. Is it the right to copy or right not to copy?
Students, please respond.
Okay. So copyright is the right not to copy. Okay. So patents, as I said, patent protects inventions. New inventions are protected by patents, whereas copyright is the exclusive right granted to a creative work. It can be used for a literary work, artistic work, scientific work. If you have, if you wrote a book, if you wrote a story, if you wrote a novel or a poem, any kind of literary work, if you do, you can apply for the copyright registration, copyright protection, because copyright protects the creative works. Literary work, dramatic work, musical works, artistic works are all protected under copyrights. And also the cinematographic films, sound recordings, broadcasting, then computer program per se, software, computer programs per se, all comes under the copyright protection. So it is the exclusive right which has been granted to the owner of such works for exploiting their work for a limited period of time. That is what copyright is all about. And then copyright actually protects the expression of ideas based on some idea, the expression of ideas, because here also idea cannot be copyrighted. We cannot copyright an idea, but what we can do is we can copyright the expression of that idea. So if you have an idea, you have to express that idea into a tangible media. You have to write it in a piece of paper or you have to record it in a tangible media. Then that document can be copyrighted, but idea as such cannot be copyrighted. That is the peculiarity of copyright. And copyright will give you a bundle of rights. That is the right for reproduction, right for translation and adaptation, right for public distribution, right of public performance, right of broadcasting. Such things are, if you write a book, in Malayalam and got a copyright for that, you have the right to translate that book to other language, or with your permission only another person can do that. So you have the exclusive right over your book. So that is the protection copyright is giving you. And another difference, another advantage of copyright is that copyrights are international rights. That means an Indian copyright will be valid globally. So you do not have to apply for a copyright in each and every country. You can apply for the copyright in the Indian Copyright Office, which is situated at New Delhi. So only one application is enough for getting the copyright protection globally. These are all the subject matters of copyrights, like the engineering drawings, books, paintings, photographs, sound recordings. All these things can be protected under the copyrights. And regarding the authors of copyright, authors, in the case of a literary work, who is the author or who is the owner of the copyright? That is what I meant. Okay, so in the case of a literary work, the author of that work is the owner of that copyright. Whereas in the case of a music, it will be the composer, not the singer. Composer is the owner of the copyright for that music. In the case of artistic work, it will be the artist. In the case of photograph, it will be the photographer. In the case of cinematographic film, it will be the producer, not the director, producer. He will be the owner of the copyright for that cinematographic film. That is regarding the authorship of copyright. And as I said, copyright means the right not to copy. Okay, if you copy somebody else's property, then that is a copyright violation. But there is something called a fair use in the Copyright Act. Fair use means we can use a small portion of the work, a copyrighted work, for educational purposes. We can use a small portion of the copyrighted work or any other materials for educational purpose. For example, take the case of a textbook. So textbooks are all copyrighted works. I don't know how many of you are aware of that. All the textbooks are copyrighted. A teacher might have spent a lot of her time, energy, and her intellectual activity to come up with a textbook, and she got a copyright for that. But what we do usually, we take a Xerox of the entire textbook and we will use it for study purpose. But that is a copyright violation. Whereas we can take a one or two chapters for study purpose, that is comes under the fair use. So fair use means we can use a small portion of the copyrighted work for educational purpose, but we cannot copy the entire work for that educational purposes. That does not come under copyright. So there are a lot of myths regarding copyrights, like ideas are copyrightable. As I said, we have to express that idea into a tangible media, then only copyright will be granted. The need to register your work to get a copyright. As far as copyright is concerned, registration is not mandatory. If you write a book today, at the completion of that work itself, you will get a copyright for that. But for legal protection, you can apply for a copyright registration. The procedure is very simple, and you will get the copyright registration certificate within 3 months itself. So that is a very easy job. But as far as the Act is concerned, registration is not mandatory. But we have to prove that in the case of any infringement, you have to prove that on such and such date you have created that work and you are the owner of that copyright. But on the other hand, if you got a copyright certificate, that certificate will speak all about it. And there is another thing is that I used a copyrighted work without the knowledge that it is copyrighted. We cannot make that as an excuse. You should know whether that work is copyrighted or not. Then fair use allow me to use any copyrighted work. As I said, you cannot copy the entire textbook for the study purposes. You can use a small portion of that book only for that study purposes. So that is another thing. And another thing is that copyright does not apply to internet materials. We always feel that copyright does not copyright anything which is available in the copyright. Sorry. So we always feel that anything which is available in the internet is free. It is not copyrighted. It's like that. We feel it like that. It's not like that. All the information, all the documents which are available in the internet are copyrighted only. So if you are copying such contents, as per the Act, you have to get the permission of the website owner. Then only you can use that copyright, that work. And I need to copyright my work. As I said, copyright is an international right. Then once a copyright is sold, the author loses all the rights. It's not like that. If I sell my copyright, then I will lose my economic rights, but I will always have that moral right. Then most important thing is that copyright violation is a serious offense. In all the other violations, only civil remedies came, but in the case of copyright violation, it will be the criminal remedy also. Minimum 6 months to 2 years imprisonment will come in the case of a copyright violation. So we have to be very careful regarding the copyright infringement. Then copyright protection is generally for a period of 60 years. And in the case of a literary work, it will be the lifetime of the author plus 60 years. And cinematographic film, it will be 60 years. And broadcasters and performers right, it will be 25 years. That is the term of copyright protection. Basic term of protection is 60 years. And this is the fee structure for filing a copyright for the literary, dramatic, musical, or artistic work. Only 500 rupees to be paid. Cinematographic film, it will be 5,000 rupees, and sound recording, it will be 2,000 rupees. There is no renewal fee to be paid. Only this much fee to be paid, and you will get the protection for the lifetime plus 60 years. That is the term of copyright protection. And that's all about the copyright. And the third form of IP is trademark. This topic is also more familiar. This term is also more familiar, and we used it to refer it like brand, isn't it? Brand. Trademarks are referred like brands. So trademark is nothing but the companies will be using some distinguishable signs or symbols on their products to distinguish their products from that of its competitors. So they'll be using some distinguishable marks, so that customers should be able to identify whether from where that product comes from. That is what trademark means. It is been represented graphically, and the main purpose is to identify the source of that product, from where that product is coming. That is the function of a trademark, and it guarantees some quality over that product. It can be a word mark like Ford, Toyota, or abbreviations like IBM. All the images which I have shown here are trademark only. It can be a number, letter, slogan, sound. In the case of the Nokia phone, the sound which comes out when we are putting the phone on, like that. So that is a trademark one. Even smell marks are also there. If you are able to identify the company of a perfume based on the smell, then that can be a smell mark. Logos, combination of colors, holograms, etc. all comes under trademark only. Then regarding the trademark, there is something called a service mark. Service mark means the mark which are capable of distinguishing the services, like South Indian Bank, State Bank of India, KSRTC, Indian Railway, because they are providing services and they want to distinguish their service from their other competitors. So for that, they are using some service mark, that is service marks. Certification marks are also there, ISA mark, ACK mark, hallmark. These are all the certification marks. Okay. And then we have collective mark also. Collective mark means the mark which are being owned by a group of professions. For example, this mark belongs to doctors. So any doctor can use this mark. Chartered accountants can use this mark. So just to distinguish their profession from others, they are using some mark which is known as a collective mark. And this is the fee structure, 4,500 rupees. Don't think like that trademarks are only for companies. It's not like that. If yourself, if you are designing a logo for your personal purpose or for a educational event or something, events in your college, you can apply for a trademark registration for that logo. Then you can only use that logo. Without your permission, nobody else can use that logo. So trademarks are also applicable to the individuals. Also the logo of your institution, that can be registered as a service mark also. So protection will be initially for a period of 10 years, which can be renewed indefinitely. Every 10 years you have to pay the renewal fee, and it will get renewed for another 10 years. So like that you can renew it indefinitely. So that protection is indefinite. And next we have got industrial design, which is another form of intellectual property rights. Industrial design is nothing but the aesthetics of an article, the external appearance of an article. If the external appearance of an article is a new one, if it is unique from the existing one, then you can apply for a industrial design protection. The aesthetic part or the ornamental part of an article can be registered under industrial design. It has nothing to do with the technical aspects, only the shape or configuration of that product. For example, the shape of this perfume bottle, if it is a unique one, if it is a new one, that can be registered as a industrial design so that nobody can copy that design. That is the purpose of getting the design protection. It has nothing to do with the technical aspects. But the design must be new and original. That is the condition. Shape, configuration, patterns, and all can be registered under this industrial design. The term is 10 years, initially for 10 years. These are all the examples of industrial designs. All the ornaments, majority of the ornaments are being protected under industrial design, because that design will add the value of that ornament, that product. Design always add the value of every product. So it's very important. So they are registering industrial design for that. These are all the examples. This pen, it is a design registered product. All the automobiles, then design like carpets and all, they are all registered under industrial design. Only 1,000 rupees is the fee for registration, and renewal fee is 2,000. So protection will be initially for a period of 10 years, can be renewed for 5 more years. So maximum 15 years you can enjoy the protection of this industrial design. Then another form of IP is in the geographical indication. Geographical indication means if the product, if the goods coming from a particular area, particular region has got uniqueness, has got a quality or reputation, which are due to the place of that origin, then such products are being registered under geographical indication. So basic function is to identify the origin from where this product is coming, from which part the product is coming. That is the function of GA. It must originate from a definite area or defined area. It must be originated from that, and any association of persons, producers, because the product should have uniqueness, it should have some reputation and some quality, which are attributable to the place of origin of that product. And only you will get a GA registration. These are all the examples. Many of them are very familiar to all of us, like the Darjeeling tea, Kanchipuram silk, Alfonso mango, and like that. So the name itself relates to from where this product is coming. Darjeeling tea means it comes from Darjeeling, Kanchipuram silk. And as far as the GA is concerned, in Kerala, we have got a number of GA registered products. More than 30 products were registered under GA, like Navara rice, Palakkad and Matta rice, Kaipad rice. Lot of rice varieties are there. Alapi, Kayar, Pokali rice, Palakkad Mattalam, Nilambur teak, Marayur jaggery, Uttambulli sari. Lot of more than 30 products are registered under the GA from Kerala. This is the fee structure, 5,000 rupees, like that. And similar to that of the trademark, protection will be initially for a period of 10 years, but it can be renewed indefinitely by paying the renewal fee. And this is also another form of IPR, that is the semiconductor IC layout design. Not that much important as that of the others, but the layout of integrated circuits, the layout of components inside the integrated circuits can be registered under the IC Layout Design Act. The protection will be for a period of 10 years. And the final form of intellectual property rights is trade secret. So the best known example for a trade secret is the recipe of Coca-Cola. So certain companies, they will keep their business information, maybe some formulas, some vital information, they will keep it as secret only. So such things can be protected under the trade secret. The first slide of patents, I said, for getting patent protection, you have to fully disclose your invention. So if you are not willing to disclose your invention, you have another option, that is keep it as a trade secret. Keep it as a secret. And what Coca-Cola has done is that they have kept a secret. They have not applied for a patent protection, but they had kept it as a trade secret only. So they are still enjoying the protection. There are advantages as well as disadvantages, because trade secret means as long as you keep it as a secret, you can enjoy the protection because nobody else can copy that. But once the secret is lost, there will not be any further protection. But whereas in the case of patents, patent protection is limited to 20 years. After that, it will become a public property. But in this case of Coca-Cola, they have been enjoying for so many years for that protection. If they would have filed a patent for that recipe, then after 20 years, anybody can make the Coca-Cola recipe in our home. We can even use that. Since they have kept it as a trade secret, we cannot use it. We are not aware of that recipe. So that is the advantage of trade secret, and there are disadvantages also because there is no legal registration for this trade secret. You yourself have to keep it as a secret. That is the disadvantage of trade secret. Not only Coca-Cola, the KFC, Cadbury, Dairy Milk, and many other products are being kept as trade secret only. Because just when the invention is not patentable, you can apply for a trade secret. Then patent protection limited to 20 years, but secret can be kept beyond that period. That is another reason for applying for keeping it as a trade secret. And for taking the patent protection, you have to pay the fees and all. But for here, no fee is involved. These are the advantages of trade secret. So that's all about the 7 forms of intellectual property rights. But we always feel it like that a single product can be protected by only one IP. It's not like that. Just take the example of this pen. Suppose, just imagine that this is a new pen. It's a new pen only. Okay. So that technology part, the ink flowing mechanism, the technology part of that patent, that pen can be patented. They can be applied for a patent protection. And if the shape of that pen is unique from the existing one, that shape can be registered as a industrial design. Whereas in the case of that brand, if it is a Parker pen, so that can be registered as a trademark. So single product protected by multiple forms of intellectual property rights. For example, also if it comes up with a small literature on how to use that pen, then that literature can be registered as a copyright. So single product protected by multiple forms of intellectual property rights. Then as a nutshell, we can summarize it like that. Patents protects inventions. Conditions are novelty, inventive step, and industrial application. Protection up to 20 years. Renewal will be for every year. It has to be renewed, and registration is mandatory. Whereas in the case of trademark, which protects logos, symbols, trade names, and all, the protection is indefinite. Any number of years we can enjoy the protection. For industrial design, protects the shape, orientation, and pattern of the article. It should be new and original. Maximum protection is up to 15 years. Whereas in the case of copyright, it will be 60 years, literary, dramatic, musical works. Condition is that the work should be original. Copied works cannot be registered as a copyright. And finally, the geographical indications, which protects the goods having quality, uniqueness, and reputation. Again, the protection will be indefinite. We can pay the renewal. By paying the renewal fee, you can enjoy the protection indefinite. Then as far as the IPR is concerned, there is an agency called the World Intellectual Property Organization, WIPO, World Intellectual Property Organization. Which governs the IPR related matters between different nations. That is the WIPO. WIPO is situated at Geneva, Switzerland, and every year, April 26 is being celebrated as the World Intellectual Property Day. April 26th is celebrated as the World Intellectual Property Day. So, since you are from the pharma sector, I have included a few case studies with regard to patents. One is the Novartis case. You may be familiar with that case. Novartis case. Actually, in 1997, Novartis, it was a Swiss-based pharmaceutical company. They have filed a patent application for their anti-cancer drug, that is the Gleevec. Okay, they have applied for a patent in the Chennai Patent Office, and in 2005, the Chennai Patent Office has rejected the application, that patent application, citing the section 3D. 3D is like the mere discovery of a new form of a known substance, because that beta crystalline form, that another form was already known, which was already patented in India. So, citing that section 3D, they have rejected the patent application, and in response to that, the Novartis filed writ petitions in the Madras High Court, and they have referred the case to the Intellectual Property Appellate Board in 2007, and they also rejected the appeal by the Novartis, and finally they went to the Supreme Court to get the decision reversed. But Supreme Court also upheld the patent office rejection, because citing the section 3D, the new form of a non-substance cannot be patented. Based on that, the patent application from the Novartis has been rejected. That is one case study. And another one, we have the Natco Pharma versus the Bayer Corporation, right, which is the first case of compulsory licensing being obtained in India. So Bayer Corporation is an American subsidiary of a German multinational company, and they invented a drug called sorafenib tosylate. And what happened is that they applied for a patent in India, and they got the patent granted in 2008. So what they have done is that it is also an anti-cancer drug named Nexavar. So what they have done is that even though they have been granted a patent in India, they have not made that product into the market, so that the Indian patients are not able to get that medicine. And since they have got a patent for that, other companies are not being eligible to come up with such a drugs. So that happened. So then the Natco Pharma Limited, which is a Hyderabad-based company, they approached initially they approached the Bayer Corporation for a voluntary license, but they have denied for that. Then they applied for the controller of patents, that is the patent office. They applied for a compulsory licensing in 2011. So based on the hearing and all, the compulsory license has been granted to this Natco Pharma Limited. So you can see that actually the for the Nexavar drug for a one month dosage, it costs 2.8 lakhs, which cannot be afforded by most of the patients. Okay, so after the compulsory license gets granted, the price got reduced to 8,000 rupees. That is the Natco Pharma. They sell that product for 8,000 rupees. That was the condition in which so it could be affordable to all the patients. So that is the only compulsory licensing case which was been granted by the Indian Patent Office. Compulsory licensing. So that's all about the first part of session, that is about the IPR. And since IP management for startup is also included in this topic, I just put some slides also. As you know, the relevance of startups in the technological progress of every nation. So as far as a startup is concerned, the intellectual property will be the most valuable asset. Only the startup which has got an innovative product or a process in their hand, they can only survive in the market. So IP is very important, that of their physical assets. And if they have an innovative idea, they have to patent that idea or that innovation. If they have an innovation, they have to patent that innovation. Then only they can succeed in the market. Okay, so patent is very important as far as startup is concerned. Not only the patents, the trademarks, like the logo. You have to create a brand for that company. So for that, logo is very important. So we have to register for a trademark also. We have to protect the logo under the trademark protection. Apart from that, if there is something eligible for getting the industrial design protection, you should do that. Startup should do that, because all the IP will add the value of that product. Okay, so the customers as well as the investors will always look for whether that invention is patented, whether that technology is patented, like that. Then only they will prefer opting such innovations, such products. So patent is very important. Along with that, this trademark, industrial designs, and even trade secret. If there is something which cannot be patented, we have to keep it as a trade secret. That is also very important. And there are certain strategies to be made, like IP protection should be made the top priority. First thing is to protect it. At the earliest, you have to protect it and register it. And that is one thing. And the second one is, and you have to make sure that you are not violating the IP rights of any other person. That is very important. Knowingly or unknowingly, if you are copying somebody else's innovation, you will be in big trouble. So that part is very important. You have to make sure that you are not copying that. And you should have to make a clear policy regarding the IP filing and all. There should be a proper policy document for the startup, and the agreement should be there. There should be proper agreements like the non-disclosure agreement between the employer and the employees, stating that I will not disclose this information to others because it's a secret document. So you have to get that agreement executed between the employees and all. So that is also very important agreements. And recently, you may be aware that the central government has instituted the scheme for facilitating the startup, that is the SIPP scheme, in which the patent applications from the startup can be processed through some facilitators, which is empaneled by the Controller General of Patents. Only thing you have to do is, if you have a startup and you are applying for that patent protection, you have to pay only the official fee. You have to identify the facilitator, approach him, and only the official fee need to be paid. The statutory, the other professional fees will be paid by the government only. That is very important. And also in Kerala, we have got the Kerala Startup Mission. They are operating a scheme for reimbursement of the expenses with regard to the filing of patent. So even if you are filing directly, after that you can apply for the reimbursement in the Kerala Startup Mission, so that your expenses will get reimbursed from that. And I have put some a few startups, the case studies of startups, just to show you that how they have done that. So Gen Robotics, you may be familiar with that. Gen Robotics, that is the first robotic company which invented a robotic mechanism for the manhole and sewer line cleaning in the world. So they have branded it like a Bandicoot. So what they have done is that they used some technologies like robotics, hydraulics, and all. And these are the founders like Arun George, Vimal Govind. There were 4 founders of this company, and they were initially situated in the Technopark and later moved to Bangalore and all. So what they have done is that they have developed a semi-automatic sewer cleaning robot which will go 6 meters deep in the manholes, and they will do the cleaning and they will come back. So manual work gets reduced, and they got a number of achievements also, and they have filed a patent. Initially itself, they have filed a patent and get it protected, and after that only they got it published and all. They got many achievements like the Hindu BLN Inch Maker Award 2020, Infosys Award, Amrit Award, lot of awards they have got it. It's a Kerala company only, Trivandrum based company only, but they have reached to a higher level only based on that technology, only that product. Similarly, there is another startup company, that is the Shastra Robotics. It is a Kochi-based startup. They are making the industrial robotics. They are in robotics, and they are making small robots for the big companies like Bosch, HCL, and all. And they are also doing a wonderful job in the field. And they have also got some. They have filed a patent for that. And achievements like includes top companies are all Mahindra, TCS, Tata, Alexa. They are all the clients of this company. So that was also a Kochi-based startup only. And Consala is an innovative medtech startup in Mumbai. They are in the health field only. So they have made something like a Celtron, that is a patented brainchild. Okay, it is based upon the quantum resonance therapy, that is physiotherapy. It's a device for the portable physiotherapy, and they have also applied for a patent in the PCT application and made some achievements like many awards they have got it. So you can see that all the technologies were actually protected by patents, and then only they have proceeded further. Only because of that they could survive in the field. And Aether also, you may be aware of that, Aether electric vehicles like that. And what they have done is they have made a number of applications regarding the battery module, electric vehicles, charging modules, and they have applied around 7 or 8 patent applications, and they have also succeeded in the market. Just to show you that how the startups, how they have managed their intellectual property. First, they have protected it, and then they have effectively utilized that IP rights, and then they have grown to the higher level. That is what you have to do. IP should be the main component of a startup. Innovations or any creative also comes under the IP protection. So first protect it and then enforce it, legally enforce it. Then only we can succeed further. So this one also Vedantu Innovations, and they are in the field of an educational technology startup, online training and all, and they have got a patent application granted from US, like the system for measuring the effectiveness of an interactive online learning system. So it's an online learning system. They have applied for a patent in the US. They also got some achievements like awards and all. So that's all about the various startups. So that's all about the various forms of intellectual property rights in a brief mode. So if you have any queries related to patents or any other IPs, you can either contact me either through email or phone. And we have an intellectual property rights information center Kerala functioning in the KCST, which is the nodal agency of the Kerala state for the IPR related matters. So we are providing all the services with regard to the filing of patents and other forms of intellectual property rights. So if you have any requirements related to the IP filing, you can directly contact us, because we are the nodal agency of the state and we are providing all the services. A patent search we are providing free of cost, trademark search we are conducting free of cost, and all the advices with regard to the filing of IPs we are providing. So if you have any queries, any requirements, you can freely approach us. We will be providing all the support to you. So if you have any queries, you can either mail to me or just telephone me. We'll provide all the guidance to you. So thank you very much for your very patient hearing. If you have any doubts, I would be happy to clear. Thank you.
Thank you so much, sir. I don't think anyone else can explain these topics in such a simple and easy way, sir. Thank you so much.
Thank you, sir.
Exactly, sir. If you ask students don't interact, let them interact.
Yeah, yes, sir. Yes, sir. That's what I'm thinking. Students, please interact with sir. Any queries?
Shafiq sir, how long it takes for a patent to get published? It is getting published, sir. But how long it takes to get granted, sir? It depends on the type of patent, or
Yes, sir. Yes, sir. It depends upon the type of patents, and normally it will take around 4 to 5 years time to get it granted. But recently, in order to promote the startups, government has like amended the Patent Act, and they have introduced the expedient examination procedure. So startups can use that procedure. They can apply for that. So if you are opting that, you may get the patent within 1 to 1.5 years time. So that is the best thing. We will get it. If you apply through apply as a startup, and if you opt for that expedient examination.
how do you know what is the current status of our patent, sir? We have to enter our patent application number and we have to see this.
Yeah, just type the patent application number in the IP India website. The present status, the current status will be cited in that website itself.
Okay, sir. Anyway, if you have any doubt, I'll contact you personally.
Sure.
Sir. Students,
we will
if
be
you are
happy to provide.
Yes, sir. Like what Akash sir told, you just explain patent in our style. I mean, you all explained some examples. That was really a good.
Sir, one more note, sir. You told about fair use and that fair use of copyright. Sir, is it similar to the Creative Commons, or we have to attribute the author in fair use?
Exactly. We have to acknowledge the author also. That you have to do just a small portion of the work. If it is for an educational purpose or a research purpose, that won't make an issue. So for that only we have got that fair use provision.
Okay, sir.
Always better to acknowledge the author. Always better. Yes.
So students,
either they have understood everything or they understood nothing.
'82 participants are there, and around 100 persons are watching in YouTube also. If anyone watching in YouTube, have any query, you can put it as a comment in the comment box. Don't think no comments there.
Okay, then sir, we can wind up. No issue. You can contact me anytime. You can contact me.
Okay,
you
sir.
can
Okay,
give
sir.
my reference to them.
Sure, sir. Sure, sir. Kadar, sir?
Can you able to hear me?
Yes, sir.
Hello. Okay. We shall proceed. You can propose photo. Shafiq sir, thank you once again sir for accepting our invitation. And you are our first choice during our quarter
Thank you,
two
sir.
seminar of IIC. Okay, sir. Before that, we shall play. Before winding up, Akash will give vote of thanks and followed by.
Thank you, sir. Now, I welcome Dr. Agash Maradagam, Vice Principal, National College of Pharmacy, for the vote of thanks.
Thank you. First of all, I would like to thank Dr. Shafiq sir for giving such a wonderful lecture. And it was the most simplest way I think anyone can express these topics. Thank you so much, sir. And I thank our principal, Dr. Sujit Verma sir, for giving us an opportunity. I thank the IIC coordinators, Dr. Kadarvel sir and his team. And I thank the management. I thank the IT team, everyone for supporting this event. Thank you so much. You have to fill up the feedback form for getting e-certificate. That will be posted soon. So we are writing up. Thank you, sir. Sir, once again, thank you. Thank you so much.
Thank you.
Thank you, sir. It's the end of today's sessions. Let's wind up the session for intellectual learning with the national anthem.
शुभ आशीष मांगे गाहे तव जय गाहे